Good afternoon. My name is Alina Shevtsova. I am an immigration attorney from Brooklyn, New York. Today's legally speaking seminar is dedicated to expedited removal orders. What is it? Well, imagine you received a B1, B2 tourist visa and you would like to come to the United States. You're very excited. You thought that all the troubles were past you after you received the visa. You come, you land, your plane lands in JFK, you come to the CBP agent and he's asking you, "Sir, do you know anybody in the United States?" You say, "Yeah, my sister lives here." It's like, "Oh, how interesting. And what do you plan to do here?" "Well, I'm planning to visit her. Maybe she's going to sponsor my green card too." And the CBP officer is going to tell you, "Sir, I believe that you do not in possession of a valid immigrant visa, and hereby I deny you admission into the United States, and your visa is canceled." That's just the beginning of your trouble, because now you're going to be detained probably for at least 24 hours or till the next claim. You're going to spend a very unpleasant time in the CBP detention. You're going to be questioned in detail about the purpose and your history of related to the immigration into the United States. And chances of you getting visas in the future are almost zero. So how to avoid this situation and what's going on with that? Well, basically, the fact that you receive a visa does not guarantee your admission. And I believe there is a warning like that in the consulate and on the visa itself. What happens is that the CBP officer or Border Patrol officer is going to determine your eligibility for the status you're seeking when you're coming to the United States at the border when you appear in front of the agent. And if the officer determines that your declared intention does not correspond to your real intention, the visa will be canceled and admission will be denied. Also, admission can be denied based on fraud, misrepresentation, but very often it's the reason that I told you, that you are not in the possession of a valid immigrant visa or some kind of a document that they say you should have. And usually it happens because you said that you're coming to see your fiance and you're planning on getting married while you have only B1, B2 visa, or that you're going to work, or the office determined. Very often the office says, "May I see your cell phone, please? I see that you are coming into the United States very often." They take your cell phone, they search your cell phone, and oops, there is an email from your employer saying, "Hey, Anya or Jose, I'm waiting for you. Your salary is $10.50 per hour. When are you going to start working?" So that's a problem. Basically, your visa is going to be canceled. But that's not the worst thing. The worst thing is coming next. You're going to be expeditiously deported or removed out of the United States. You cannot see and will not be entitled to see a judge in this situation. And you will not be able to come back into the United States without a waiver for 5 years. So now let's see how one can avoid this situation. Well, first of all, you need to apply for a visa that is suitable for your purpose that you're going to try to accomplish in the United States. If you're going to see your fiance and you guys have marriage plans, you need to apply for a fiance visa. And I know that it's probably more expensive and longer, but trust me, it's much better than being deported at the border. Second, sometimes such waivers, such orders are results of misunderstanding. Sometimes people cannot express themselves clearly. Sometimes it's something else, and the officer all of a sudden becomes very stiff and he doesn't believe you anymore and he just cancels your visa. What can be done in this situation? If it's a clear result of misunderstanding, here a lawyer probably can help you. Even though you cannot see the judge, but a lawyer can see and speak with the supervisor of the officer who found you inadmissible and perhaps convince that person to revoke the order, because that order can be changed. It's an administrative order. It's issued by an administrative officer, and it can be canceled by an administrative officer. Usually they call CBP port director. That's one of the options. Also, if you clearly got caught doing something that, you decided to use a tourist visa to look for a job in the United States, okay? You have one more chance. You can ask to withdraw your request for admission. You sign a special form, and the expedited order of removal will not be issued against you. Well, in the system, they're probably still going to have a note that you did something wrong. And of course, if your visa is going to be canceled and you're going to reapply for the visa, you will have to explain yourself. But at least in this situation, you don't have this 5-year bar. That is really, really not good to deal with. Well, let's say it didn't happen and you couldn't fight the order right then and there, and your request to withdraw your request for admission was not granted, and now you do have an order of deportation. What do you do? Well, first, you're going to be returned back to your country. And second, if you really have a good, valid reason to come back to the United States, of course, you will have to disclose this incident. And after, consul will find you inadmissible based on that order. And in my practice, for whatever reason, sometimes they don't, because I guess it's an administrative measure that can be administratively forgiven, but if they do, you will have to file for a special waiver of inadmissibility or waiver of permission to apply for admission after an order of removal. That's correct name for that waiver. The good thing about this that waiver, that form, it's filed with a port and place that issued you the removal order. So if you have a reason, and if you're an honest person, you're explaining why you need to come back, the waiver is probably going to be granted, especially if you're now married to a US citizen or something like that. So the consequences of having removed out of the United States are pretty drastic, but not really the 5-year situation. The consequences are much worse if, despite that order, you're going to enter the United States. Many people do that. They cross the border with Canada or somewhere in California, and then they're removed again. That's caused a permanent bar very often, depending on how long you've been previously in the United States, or maybe 20 years of inadmissibility. So if you do have this expedited removal order, don't take it lightly. Consult with a lawyer before you attempt to do anything else, like crossing the border or forgetting to tell about that incident when you're applying for visa, because the result of this forgetfulness can be much harder than 5 years of inadmissibility. And very often, as I said, that administrative waiver can be dealt with relatively. It's not easy. Nothing is easy when we talk about immigration in the United States, but it can be, it's simpler than dealing with something drastic as 20 years of inadmissibility, or God forbid being charged with criminal violations of the United States immigration laws. I hope this little video was helpful. So if you have questions about expedited removal orders, you can find more information on my website, www.shaltsova.com, or by calling my office, 917-885-2261. Thank you.